Hello and welcome to Runkle of the Daily. My name is Ian Runkle. I'm a Canadian criminal defense and firearms lawyer. As you may know, I've been kind of binge watching the whole Rittenhouse trial, but I do try to keep my commentary at least applicable to the Canadian context. That said, there's a couple of things that have come up in that trial that I think connect to something I've long said, which is that if you're going to do criminal law, whether that's as a Crown prosecutor or on the defense side, you should probably know guns, at least have a passing familiarity. And there's a couple of moments that have come up in the Rittenhouse trial that I think make for good illustrations of this. Now, I don't have Canadian courtroom video because we just don't do that here. So I'm going to be using those clips to illustrate some things that have gotten on my nerves in the past and that I think make the larger point that really it's important that if you're going to be doing work that involves firearms, you need to at least know the basics. So let's have a look. I'm going to start out with a clip of ADA Binger here.
And as you'll see in a little bit, Mr. Rosenbaum doesn't take kindly to people pointing guns. I don't think anyone does. That's not unusual. No one wants to have the gun pointed at them, and no one wants to watch anyone else do this to someone else. We have the gun. It is in evidence as exhibit number 28. I'm having the detectives check it to make sure that it is safe. The defendant comes running in and drops the fire extinguisher on the ground like this. And then raises his left hand to the gun and points. This is what we see in the video. Him putting the fire extinguisher on the ground and then raising the gun.
There were initial reports that he was pointing this gun at the jury, and I have to say, at first I was skeptical of this, because why would you ever do that? It's hard to tell from the video because we don't get to see the jurors, their identities are being protected, and different courtrooms have different layouts, so it's hard to tell where the jury box is exactly. It wasn't until I was making this video that I really became fully convinced, and that's because I went back and rewatched his lead-in. And his lead-in is, wouldn't you hate to have a gun pointed at you? Wouldn't that make you angry? Detective, give me the gun. And then he's shouldering it and pointing. That's what he's trying to communicate to the jury. Doesn't this make you angry? Doesn't this make people angry when they see me doing this? And I mean, I guess he's right in that sense. Now, Kyle never pointed that gun from what the video evidence seems to show. The only way they've been able to say that is by playing enhanced or, upgraded video, and they play it over and over and over again going, see, that little blur. What he wants people to see seems to be contradicted by various other evidence. There's video experts out there who've done great takedowns of this. Check out Darth Crypto on Twitter. He's done some good work on this. But I don't buy that from what I'm seeing. I don't know if the jury has either, but regardless, that seems to be what he was trying to communicate to the jury is, doesn't this upset you? And quite frankly, I think this was highly irresponsible. ADA Binger does not know guns. And we know this because he's relying on the detective to clear the gun for him. And then once he gets the gun, the first thing he does is nothing. He doesn't check the detective's work. I'll tell you, if I'm on the range and somebody hands me a gun and says, this is unloaded, the first thing I'm doing is checking their work. I want to make sure that it's unloaded because now it's in my hands and I'm responsible for it. That's basic gun safety. He doesn't do that. Always treat all firearms as loaded unless you've just unloaded them, and even then, still treat them as loaded. The next thing is we can see how he shoulders this gun, and there's all sorts of signs that he has never handled a firearm before. So here's a little image. It's, taken by a photographer who was in the room, and you can see he's got his arm up, he's chicken winging. This is not considered a good stance. There are some people who disagree with this, in fairness to some of the, the gun bloggers out there. But it's still, nobody really recommends it. Even the people who would say that chicken winging maybe isn't as bad as all that, and again, that's a real minority voice, would say that his shoulder needs, the stock actually needs to be in his shoulder and not rising up like that. We can see that his finger is on the trigger, which again is a major firearm safety violation. Gun owners quite quickly learn your finger stays outside of the trigger guard because that's important. But no, his finger goes right to the trigger on a gun that he personally has not checked, which he is pointing intentionally, apparently, this is what's been reported, towards the jurors. And I also highlighted his foregrip, which of course, what is that? I mean, you want to actually grip the gun there. So this is clearly the stance of a man who has never before held an AR-15, certainly has never, doesn't have any experience with them. And the safety failures on this, he's just going to take the gun, sight unseen, and Alec Baldwin it towards the jury. I do not approve. And quite frankly, I think this is the thing that many judges, I think, here in courts would yell at him if he tried to do that. This is not safe. This is not a reasonable behavior. Now, you might say, oh, well, he's pointing out that Rittenhouse is such a bad guy. Well, great. You don't make that point by committing crimes and endangering people, because Wisconsin law does say you can't point a firearm. I checked. Now, he enjoys immunity because he's a prosecutor in the course of engaging in this trial. That's what the American lawyers tell me. I still don't approve of this. But this ties into why you need to have some firearm knowledge, because if you are a criminal lawyer, you will likely at some point in your career have to handle a firearm, or at least watch other people handling them. And so you need to be able to do so safely. You need to be sure that you are taking the requisite steps to make sure that you never put a hole in somebody that you didn't mean to. And surely in a court proceeding, you don't mean to put holes in anybody. I feel that that is not something that usually happens. I have had to step up, as the lawyer, to go up and tell an officer that his securing of the firearm was not securing it, and to get him to do it properly. I've had to tell various members, various people in court, be they police officers, be they other lawyers, not to point firearms at me, that this is not okay. People need to have gun safety backgrounds if you're going to handle firearms. And, lawyers have to learn a lot of things in terms of doing law, but I don't think this one is negotiable. I don't think that this one is negotiable from an ethical standpoint. I think, quite frankly, if you're going to take files that involve guns, you should at least know enough to handle them, or if you don't, you should refuse to handle them. You should say, I do not feel safe doing this. Binger is not safe handling a gun. It's clear, and he should not be doing so if he doesn't know what he's doing. He does make me angry. It makes me angry that, and his point here is not good. But anyway, I'm going to wrap that up and move on to the second point that I wanted to make here. And to do that, we have to switch to the rebuttal, because this one comes from ADA Krause.
Guns do not have handed. There's not a left-handed or right-handed gun. So, yes, the demonstration that Mr. Binger did is how it happened. The defendant was facing that way. He picked it up.
You hear that, lefties? All of the annoyances you have with right-handed tools can be solved through the power of bullshit. The statement made by ADA Krause here is profoundly ignorant, and I'm being charitable to him when I say it's profoundly ignorant, because there's really two options. Either one, he didn't know what he's talking about, or two, he's lying to the jury. And both of those I consider to be unethical, but the latter, if it was an intentional lie, would be way more unethical. I say unethical because no evidence was called on this point, so this is something that Krause is telling the jury for the first time ever as if it was some obvious fact, and it's wrong. It's just flat out wrong. It's not, it's not maybe, it's not arguable, it's just wrong. There are some ambidextrous guns, but not all of them. In fact, most aren't. So as an example, I've brought out my SIG P226. You might be saying, hey, the gun in question's an AR-15. Why aren't you bringing out an AR-15? Well, they banned them here in Canada, and it's debatable as to whether or not it's legal for me to even use it in a demonstration. So I'm not. This, of course, is checked. I don't know if you can see, but nothing in it, no magazine. So we're talking about a rendered safe firearm here. But you can see that the controls for it are all on the one side and designed to be easily operable with your thumb. So if I put in an empty magazine and just showing you that it's empty, if I'm going to drop the magazine, that's quite easy with the thumb. Just a little motion and we're done. If I want to drop the slide, again, real easy. And to decock it, there we go. Everything is nice and easy and fairly simple. Now, let's try this from the left hand. Because if you see, now instead of being able to use my thumb, which is fairly strong, I have to use my index finger. And my index finger is not well positioned. So in order to, if I'm sitting here with my finger, again, not in the trigger guard because I'm not Binger, I have to reach down, and it actually takes a little bit of force and is a bit of a pain in the butt to do with your index finger. I could reach over the gun, but that's, again, not that great. And when I say not that great, you want to have a hand free to manipulate the magazine as you're dealing with it, as it's dropping. I tried this earlier and I actually broke the screen of my phone because, of course, I managed to drop the magazine and it landed right on my phone. So, Kraus, you owe me a phone. Anyway, this is, there are clear handedness to the controls of many firearms. You'll also notice that this one ejects to the right. Lots of right-handed firearms do that. And of course, when you're dealing with a rifle, this is more important. Back and to the right is where your spent brass tends to go, which if you're holding the gun to the right means over your shoulder. But often if you switch, that means into your teeth, which is not really where you want hot brass to go. I was shooting one event and I was using my Tavor, and part of the staging required me to shoot it from my off shoulder. Well, I had little burnt circles in my face because the brass, was bouncing right off my chin and actually left little burn marks. They've healed, thankfully. That was a bit of a concern. But, it was quite unpleasant in the moment. The other thing that I don't think has been mentioned, lots of people have talked about, the handedness of guns, but you also have eye dominance. It's a lot easier for most right-handed shooters also are right eye dominant. Not always, but mostly. But most shooters certainly have a preference. And so when you switch from one shoulder to the other with a long gun, you are also switching which eye you're likely using. This is all a pain. This is all something that's difficult. And for Kraus to just say, oh, well, no, that's total BS. It's totally the way Binger demonstrated it because guns don't have handedness. You're lying to the jury. I mean, whether you're doing it intentionally, whether it's an intentional lie, or you're just telling them a falsehood because you don't know what you're talking about and you don't care to actually find out, either way, you're misleading the jury. You're getting further away from the truth. How is the jury supposed to decide a case when what we're telling them is false? And how are you supposed to have any credibility? How do you claim to be ethical in the pursuit of your job if you're willing to mislead a jury in this fashion? Whether, again, because you are intentionally doing so, or just because you don't care to know what you're talking about and you're just willing to say things even if you don't know. I mean, if you don't know something, just say that. That's fine. If he'd gotten up and said, listen, I don't know if guns have a handedness or not, and we haven't heard anything on that. We haven't heard any evidence on that point. I'd have no beef with him. I would say at that point, that's on the defense. Defense should have called an expert to talk about that. I can see why they might not have, because again, this evidence and this argument came real late in the day. But, that would be an issue with the defense. This sort of thing happens all the time because people watch movies and they think they know guns, and so they come to all sorts of assumptions. I've seen courts, both in written decisions and in person, I've seen things like saying, oh, well, he chambered a round, so that means he was about ready to use the gun. Maybe. The thing is you can chamber a round and then leave it there for months or years, or, it doesn't necessarily mean that it was ready to go right now in the sense of you had a plan for it. It might just mean that's how it got left. All these sorts of assumptions about things. People say, oh, this gun has no legitimate purpose. and it's a common hunting rifle. Or, judges say, oh, he had hollow point ammunition, which suggests that he was up to no good, because why would you have hollow point ammunition? Well, because here in Alberta, you're required to use it for hunting. You can't hunt big game without expanding ammunition. So this annoys me because it happens both from counsel and from, you also see it sometimes from the bench. And to my mind, this kind of thing is a situation where it's real easy for people who don't know what they're talking about to insert falsehoods without knowing that they're doing it. And it's also easy for counsel who don't know firearms to let these things slip, to miss things. It's unfortunate. And so that's kind of my rants. I mean, people who deal with criminal law and don't know firearms, you get two main problems. One, they may behave unsafely with the firearms in court, and I don't approve of that. I don't appreciate it when it's been directed my way. And two, they may end up telling the court or deciding improperly based on false information. I don't think either of those is a good thing. Thank you for watching. If you enjoyed this video, please like it, share it with your friends, subscribe to see more content. If you want to chip some dollars my way, I've got links to my locals or my Patreon below. Talking to you, Kraus. You owe me a phone. Anyway, I want to thank my Patreon supporters at the $50 level: Jonathan Wheeler, Canada's National Firearms Association, Mike, Kyle Martin, Jean-Guy Toussaint, CCFR, and the Canadian Shooting Sports Association; at the $30 level, Sights and Arms Limited and Marc-Olivier Damour; and at the $20 level, Raymond Dale McKinnon, Matt Ward, Mark Whittington, Jane Babin Luxor, Dale Nesbitt, Cameron Johnson, Bruno R., Andrew Elsich, and Aaron Del Salt. Thank you as well to all of my $10 supporters who will be in the crawl immediately following. Thank you for watching. I hope this has armed you with knowledge, and see you next time.